So patents, I want to first open with a distinction that there are two completely different kinds of patents that you'll hear people talk about when they use the word patents. One is called a design patent that protects ornamentation. A design patent just protects the look of the thing. So one of the famous design patents is actually the look of your iPhone. Just the appearance of where the screen is, where the button is, the shading of the metal. That's what a design patent covers. Think of a design patent as a way to protect a form factor, but only the look and feel of the form factor.
I believe I heard at one point that the circle button on the iPhone as well was actually challenged.
Yeah, so there was a family of cases called Samsung versus Apple and Apple versus Samsung. But yes, that dealt with portfolios of patents, and Apple eventually won those cases. Interestingly, Apple in those cases, their damages were about, if I remember right, $15 million for the utility patent infringement and something like $220 million for the design patent infringement. So just because design patents protect look, don't think that they're not powerful. But 90% of the time when people are talking about patents, what they're really talking about are utility patents. So these patent images are from some famous patents that I can use to illustrate some points. Because a patent can protect a process, and software is a process. And so one example you'll see is straight out of the State Street decision, which is a famous patent law decision, in which the Supreme Court said, yeah, software is something that can be patentable. Now, subject to a lot of restrictions we don't have time for today. But some people will say, well, can you patent things that are dangerous? Well, it turns out, and I have the revolver image here, that weapons are one of the most common patents out there. In fact, you'll see a surge in patent filings during conflict periods such as the Civil War, World War I, World War II. The Wright Flyer is patented. I use the Wright Flyer as an example sometimes because the patent that the Wright brothers got wasn't on the actual airplane. It was actually on what's called wing warping, or ways to maneuver something in the air by changing the way that the wings were formed. Also an electric guitar, so musical instruments are patentable, as are games. And so these are common categories that people ask, can I get a patent for this? Now, when do you file for a patent? In the United States, and frankly, most of the rest of the world now, we're in what's called a first-to-file world, or a first-to-file system. This means that whoever gets to the patent office first with an application for that innovation gets the patent. The old system, prior to about 5 years ago, was that if you invented first and kept an inventor's notebook, you could still swear back and get the invention rights as a patent. That's gone. So now in fact, a lot of companies that are innovative will bundle stuff they have every week or two and send it to the patent office as something called a provisional patent application. That's a less expensive way to get something into the patent office, because first to file really matters a lot today. Literally, we call it the rush to the patent office. What are your basic timelines? It takes about 2 weeks to do a patent search, get the results back, go through those results, and then go over them intelligently with the client, with you. Then, once you've made a decision to move forward with an application and actually file something, it takes about 4 to 6 weeks to prepare and file a utility patent application. And frankly, a design patent application. The reason why is because it's actually the time we wait on the drawings to come back and going through iterations of drawings with the illustrator that can take the most time. Once on file, it will take between 9 months and 18 months for an examination. It can take longer, actually, depending on the kind of technology that you have. Some biotechnologies, financial transaction, software patents, which are very rare, by the way, those applications can take 2 years or longer to get an examination. Then once you're in the examination phase, it can last months and it can last years. And there's almost no way to predict how long that wait will be. There are 5,000 examiners. I will frequently tell clients that means that there are actually 5,000 patent offices, because some of the rules about patent allowance are kind of subjective. And when you're dealing with patent examiners, you're dealing with real human beings. Some of them barely speak English and may not have a lot of familiarity with your technology area. And as unfair as that sounds, that's just what happens. And so you have to be able to, once you get into the patent office and you read what's called an office action or a letter from the patent office, you then have to re-strategize how you're going to address those issues with the examiner in order to get something allowed, you hope. How long does a patent last? It's 20 years from the day that you first filed for something. For a design application, rather, it's 15 years from the date that something issues. So it's different. But all this said, remember this, things are changing all the time in the patent office because, frankly, the system is messed up and there are enough companies lobbying for their favorite sets of rules right now that there are acts pending in Congress constantly that cover the patent system. Some of them I love and will help secure patent rights, and others scare the bejeebers out of me. And in fact, the system has become so unpredictable that in some scales of, or some surveys of what nation is best to file patents in, the United States has fallen from the clear number one into a pack of about 15 countries tied for number two. I don't know what that means if there are 15 of them tied. To in another survey, China was actually selected as better than the United States for getting intellectual property specifically for patent protection. That just bugs me to death. Any questions that have come in, Joe?
Not particularly on this, but Joe, we're going to give Joe another try here.
Sure.
Joe, are you able to talk?
Okay, well, tell you what, we can jump into trade secrets. I'm fine with that, unless, Jackie, you have any questions?
He's trying right now.
Okay.
I have one, but I'll sit on it until the end, I think, because it's kind of a wide question anyway.
Okay.
So.
Sure.
What I was going to say, I still don't hear him, but he's still having problems. He'll write it out or something. Was given all the changes, and I think this is applicable across all the things. This is another reason why, at least for me, I'm happy to pay someone who's actually monitoring all of the stuff, all the changes, right? And I can feel better, even if, I trust you know what you're doing, but at least I can sleep at night knowing I'm not going to screw something up, and I'm just paying someone else to know what they're doing.
Well, one, there's the issue of changes. Number two, there's the issue of knowing where to even look to find if something's changed. And there's something called the Manual of Patent Examination Procedure, or MPEP. There's one for Trademark Examination Procedure. The one for Patent Procedure is about 2,200 pages long. Trademark Procedure is about 750 pages long. There's not one for Copyright Procedure, but they have things called circulars, also several hundred pages. And it is amazing how many times I'll look up a rule and exceptions to a rule for something I feel pretty confident should be the case. And I will discover that there's this really weird case or decision by the patent office that additional papers have to be attached or something's there. And, you know, if I tell you what, if I was starting in law today, I would not go into patent law because it is so freaking hard to figure out what the right way to do things is before you submit stuff, because the rules have changed around. I mentioned all these different acts pending in Congress. A lot of them are there to try to clean up so many of these judicially created exceptions. And, you know, as a practitioner, it's almost impossible to keep track of which district or which circuit courts are saying what about which kind of inventions, whether biotech or software or something else. It's become a morass. Ready to jump into trade secrets?
Yeah, let's do it.
All right. So a trade secret's any information that gives you a competitive advantage, and that's actually a secret. So one of the things that really surprises me is how many times people will come into my office and they're mad at an employee or they're mad at a competitor for stealing something. And when I ask them about, well, how can you prove it's a secret? They say, oh, well, it's on my blog. Or it's in my literature. Well, it's not a trade secret if it's not a secret. So the good news about a trade secret is that in terms of low-cost intellectual property, if you're a startup company, this is the cheapest thing you can do, is actually track who has access to what and make sure that they sign non-disclosure agreements or other agreements with non-disclosure provisions in them. That's building a wall around your idea, your secret. In addition to non-disclosure agreements, secrets can be preserved by a relationship, such as a fiduciary relationship. So if somebody's on your board of directors, they don't necessarily have to sign an NDA. They should, but because they have a fiduciary duty, the court won't say, well, the horse is out of the barn because you didn't have them sign an NDA. Also, a privilege can preserve a trade secret. So if you tell your wife something at home, the court's not going to look at that and say, well, that let the secret out of the bag. Now, if she goes and tells somebody else, it's out. But at least within those relationships, it's maintained as a secret. Examples of trade secrets are, the most famous is probably the Coca-Cola formula, but it also applies to things like the 11 herbs and spices of KFC chicken. But it also applies to things that are much more, you might think, common, or compilations of publicly available information, like a customer list or supplier list. There's volumes of trade secret law in Texas just based on insurance agents taking old customer lists and calling on them. And then the trade secret that the people watching probably have are their business plan, especially as it relates to when you're going to select certain types of advertising for certain kinds of markets. And so be very careful about how much information you're letting out there, because your competition will use that against you if they can. Other kinds of trade secrets might be your actual code prior to filing for a copyright registration or actually publishing it. So trade secrets are low-cost intellectual property that is protected by virtue of you building a wall and keeping track of who has access and why they either have a duty to keep it secret, or how you go about making it secret. By the way, I was briefly in the Air Force Reserves. I don't know if anybody else was. I worked at McDonnell Douglas. Think of trade secrets as kind of like your top secret information. It's the stuff that you maintain in a locked file in a red folder, so that when it's brought out of that filing cabinet, everybody sees, this guy's holding something red. And then when you go home at night, you take it, you put it back in the filing cabinet, you make sure it's locked, and you take the key home with you. If you can go in front of a judge and tell them, here are the people that have seen the document, here's why they aren't supposed to disclose it. Yes, I keep it in a locked filing cabinet, and in fact, it's in a red folder. Do you think the judge is going to say that's probably a trade secret? Answer is yes. And in fact, that's how I've worked on a few cases where trade secret damages have been awarded. If, on the other hand, you can't show who had access to it, and maybe you took that folder home at night, and maybe you let people make copies of it. Maybe it was just left out where the cleaning people had access to it, or maybe it was in the break room and it's treated very casually. A lot of judges will bust that as a trade secret and say, well, it's not really a secret. You can't get damages for it because you're there to ask a judge to give you money because somebody else took something they weren't supposed to. So,
with a related question to this is with a lot of us actually doing coding and programs and stuff, would encrypting what you had made be enough protection to say it was a trade secret?
Well, so two parts to that answer. The encryption by itself doesn't make it a trade secret, right? You still have to show that other things have been done to preserve it as a secret, especially at the point where it could be, unencrypted.
Yeah, almost anything can be unencrypted within reason, of course.
Within reason, right? But the encryption is a way to preserve it as being secret through the points at which it's being transmitted. What's interesting about your example, if something is improperly unencrypted by a third party, it's not only a violation of trade secret law, it's also a violation of the Digital Millennium Copyright Act. It may actually also be a violation of espionage laws. So because you've taken an affirmative step to prevent access, then even if it's just a password and a username, then it triggers the Digital Millennium Copyright Act. And now if someone improperly breaks your access mechanism, it triggers the damages provisions of the DMCA or Digital Millennium Copyright Act.
That reminds me of, I believe this is, maybe it's the norm in most states, but if you leave your car unlocked and someone breaks into it, it's one crime. But if you actually lock the doors and they break into it, it gets elevated, right? So
yeah, I think it's, now I'm not a criminal lawyer, but I think that's the distinction between a robbery and a burglary, for whatever that's worth. Yeah. And then there's even another distinction for when it occurs at night. So, and by the way, criminal laws vary from state to state. So, ask the lawyer in the state you're in for specifics on that.
Yeah, we understand you're not giving legal advice.
Yeah, there you go. Not on that, sure. So, the key to protecting a trade secret, well, there's nothing to file, but you must actually keep it a trade secret. By the way, you might remember about a decade ago, there was a lady, apparently, who had offered to sell the formula of Coca-Cola to Pepsi, and she got turned in. I don't know how she got access to that formula. But let's say she had published that formula in the Wall Street Journal. It would have been the end of Coca-Cola's trade secret. So this is why there's a motivation sometimes to file a patent application on a recipe, a compilation of stuff. And by the way, some recipes are patented. Now, I haven't filed for a patent on one maybe in over a decade. But once the trade secret is gone, it's gone. And so for that reason, some people opt to select a different form of intellectual property. But if you can preserve the trade secret and demonstrate that it's preserved properly for a court, you can maintain it as a secret as long as you can, or as a trade secret, as long as it's actually a secret. Does that make sense?
Yeah, it does.
All right. So I mentioned it's the easiest to create. It's the easiest to lose. That's why.
Yeah.
Any questions on trade secrets?
No, but Joe, he changed mic, so we're gonna give it one more try here, real quick.
All right.
Okay, how about now?
Hey, we can hear you.
Oh,
Oh, yes. That turned out to be a setting in this Zoom software where it picks the wrong mic by default. So,
that happens a lot. Yeah.
Anyway, so here, I don't want to make assumptions about the people, the audience today, and I guess there are 40 some. And I think many of us came to this through being involved with Jackie and Joe on these AutoHotkey webinars. So I think most of us are probably, and maybe I should just speak for myself, but small software developers. We write programs here. You mentioned some $100 million situation a while back, and we're not $100 million kind of guys here, I don't think. So, my situation is I've got a portfolio now of maybe a few dozen programs that I've developed over the last 10 years, all in AutoHotkey, and now I'm trying to clean up the portfolio and get it to the point where I've got standard user interfaces and good. The reason I asked the question earlier about program names, where I've got a unique program name. Some are acronyms, some are not. Some have taglines, and so what I've just been doing is putting the TM on it, and as you mentioned earlier, that's worth about zero if it comes to a court case. So
it's nothing. But.
Right. So
but it might scare away people.
Oh, maybe, and it looks good on the cover page of my manual. So, I mean, I guess it makes me a little bit unusual, maybe as AutoHotkey developers. I actually produce user guides and installation guides and manuals. But the real question comes down to, and the reason I asked the question earlier about money is that if I'm sitting here with a couple of dozen programs and I finally, and the goal is for me to get a website up and get some ability to market and sell the programs, which I don't have right now. But as I start to do that, I'd like to have some form of protection on them, but I don't expect to sell a whole boatload of stuff. I don't expect to make a whole lot of money on it. And so the notion that I think you mentioned earlier could, and maybe with lawyer time as well, it could start costing a fair amount of money, especially when you're trying to protect a dozen programs or a couple dozen programs with a dozen taglines and a dozen unique program names. So what's, how are you going to deal with us small guys here and not the $100 million guys?
Well, by the way, the small guys are who I specialize in. When I mention the $100 million markets, usually what happens is I have a client that's maybe revenuing 5 to 10 million, and a competitor's taken the product and gone big with it, and so the competitor is the one that's making 100 million off of it. But to address your question specifically, this really boils down to making the right business decisions and sitting down and figuring out, well, how much money does, you mentioned 12 programs, how much does program 1 make you? How much money does program 2 make you? Go down the list. Next question, how likely is it that that program will be copied? Who's going to steal it from you? Assess that. Then you want to look at, well, if it's stolen, what might happen next? And at that point, at the end, you might recognize that some of the programs that you have are particularly vulnerable and particularly valuable. Well, those you probably want to protect. You probably have other programs that aren't particularly vulnerable, maybe a cash cow, but you trust whoever's licensing it for whatever reasons, and maybe you have some security keys in there to make sure that if it's used improperly that it turns off or something. You'd be less interested in protecting those that you don't think are likely to be stolen or that don't make you money. It's, for example, I haven't registered a copyright on the presentation that was just made today. Why? At the moment, I don't care if anybody steals it. In fact, it's kind of a work in process, so I haven't even finished it yet. But just because you have something doesn't mean you should protect it, but you want to consider it. That makes sense?
Yeah, it does. The problem is you mentioned, sit down, look at each program and, assess how much money you're going to make from it. The problem is on day one, you make nothing on it. And you mentioned that it's actually, though, important to do this early in the process. So like if I need to do it within the first 3 months or something, then I'm really betting on the come. And I guess what I need to do is analyze of those couple of dozen programs in my portfolio, which ones are likely to make more money and not spend a whole boatload of money up front protecting all of them. But it's obviously a catch-22 here, in that it's hard to know what of these programs are going to sell and which ones are worth protecting, and ultimately how much revenue I'm going to get from them. And frankly, I don't have a clue.
Yeah, and and that's the honest answer, right? The flip side of this are the clients like the one I met with before this meeting, who discovered that somebody's diverting customers based on their name. And, my directions to them were, hey, you gotta get things registered before we can go enforce them. And that's going to take about 3 months. Boy, it's hard to stomach people stealing stuff from you for 3 months before you can go enforce it. So it's a balance. You don't want to be at one extreme or the other.
Jackie and I can talk about this offline, but my background's in market research, Joe. Maybe we can plan a webinar to talk through how do you evaluate, how do you come up with your best estimate of what a given thing is worth, right? Because it's estimating the size of the market, how much money you're going to make off each one, and a lot of other factors of things. But maybe that's something we talk through of just to help decide, prioritize, and gauge some idea, right? So, yep.
Okay, thanks to both of you. Appreciate the comments.
Welcome.
I didn't see any other questions come. Oh wait, does a license have any power if you don't copyright your code? I'm not sure what is meant by license.
Yeah, I think I know what he's asking.
Okay.
So let me take a shot at this. License agreements apply to, rights to use a name like a patent or a trademark or a trade secret or code. Frequently, a license will articulate that the thing being licensed is a product. Sometimes a license will articulate that the thing being licensed is all intellectual property related to XYZ. Sometimes it will say it's the license of a patent or the license of a trademark or the license of a trade secret. Trade secret licenses are really common in franchise situations. So the answer of does a license apply to unregistered copyright material depends on the language, the very specific language of that license agreement. Probably it does, because if frequently what you'll see in a license agreement for code that's licensed is it will use a phrase like the code is being licensed or copyrightable code is licensed. You'll rarely see the phrase the copyrighted code, but it's usually not stated at all, or it's stating registered or registrable code.
There was some clarification here. So he said, like on GitHub, you can select a license, but is that actually protecting you?
Protecting you. Okay, now we go to the two big questions that we talked about at the very beginning. Bucket 1 questions, can I use it? Bucket 2 questions, can I make it exclusively mine? And so the question of can I protect it, do you mean can you use it without being sued, or do you mean can I register it independently? I think this question goes to that bucket 1 question. Can I use it if I'm licensing it on GitHub? Is that correct?
I don't think, well, I mean, because the initial question was, does a license have any power if you don't copyright your code? This is from the same person. So I'm thinking it was more of the other example you gave of, does it give you any protection? Regardless, he said he thinks you answered his question. So
okay. Yeah. By the way, license agreements, people will think that it's a form that's sent in or something. There are about 40 common provisions in every license agreement, and each of those 40 provisions can have degrees of favorability to one party. They can be neutral, or they can have degrees of favorability to the other party, and then they can describe the subject matter of the agreement in different ways. A license agreement is a very fluid thing. And so don't think of a license agreement as a form. That will trip you up every time.
So I had one that's kind of related to that. In the business, let's say I have a product, a software product I've created, but it's very, very specific for Steve. You have this thing where you're doing something, and we've agreed that I'm gonna create software for you. You're not actually going to own the IP about it, right? I'm writing it. I own the IP, but we want to get you to sign an NDA and saying you're not going to go and try to peek into the code itself and rip it out and then fire us and just take the code, right? Do we have to worry about any of the copyright and trademark and any patent, anything with that when we do an NDA and sign it in our agreement up front?
Well, with the patent, yes, because it's a public use. With a trademark, it depends. Are you calling it by a brand name, and is that brand name important to you? For a copyright, you're really on the edge. Now, a sale likely triggers a publication under the rules of copyright law. If it's certain type, and when I say a sell, I mean a license. If you license certain types of software, say something that's embedded in hardware, and if it's say in machine code in a way that can't be reverse engineered easily, then that might be deemed a non-publication, such that you don't have to worry about even copyright. Now, the cool thing about copyrights, by the way, is they last life of the author plus 70 years. And even though you've lost most of what are called your statutory rights after 5 years, you can always go back, file for registration, and get these residual rights in copyright, including the right to enforce your copyright to that creation in a federal court. So that's kind of your ongoing last resort. It doesn't entitle you to attorney's fees, treble damages, statutory fees, and all the other good stuff that come if you file within 3 months. But you can kind of pull the horse back into the barn with copyrights, at least a little bit. The patents, that they're gone forever.
And then this is actually plays well into that. So Dale had asked about, it's really about protecting the copyright patent or IP, but when it's stole by someone, especially outside the U.S., right? It seems like it would get expensive trying to fight someone in India or China or wherever they are. And does the government help at all with any of that? Is it a private thing?
No, it's completely private. Absent espionage. There are some espionage provisions that can kick in and create federal statutes. If someone steals your idea, let's say that you have a U.S. patent, but only a U.S. patent, or a U.S. and European patent, but only those two. And let's say somebody knocks off your idea in China and uses and sells it in China, but doesn't enter the U.S. or Europe.
Yep.
They get away with that every day of the week.
Yep.
And so there is in the consumer market for consumer goods, particularly the sell on TV kind of goods, a concept called beneficial infringement. There's a rule of thumb in manufacturing that if you double the amount of goods manufactured, you cut your cost of manufacturing by about 1/3. And so by letting this Chinese manufacturer or Indian manufacturer make and sell their product in Asia and drive up their quantity of goods produced, you can lower your cost, and then when you sell them in the U.S., you have a much higher profit margin.
Mm-hmm.
Then you try to control all quantities out of that point of manufacturing. So that's a concept of beneficial infringement. That's less true if what you're making software. But yeah, you can go broke in a big hurry pursuing international protection where it's unnecessary or where you can't enforce it. And so, I mean, international protection is I could pick any one of these kinds of intellectual property and do a weekend seminar on international protection for any of them. It's a deep, deep topic.
Cool. Thank you.
I'll give you a rule of thumb, though. If you sell within that jurisdiction, then you might want to consider filing for protection in that jurisdiction. If you don't, you probably don't need to. Again, that's the value answer. That's not the best practices answer.
Yeah. I think we're caught up in the questions.
Cool. So my challenge to everybody is to take action. Even if you don't file for something, go through this process. Think about what you might want to protect and when you need to protect it. Just mentally go through that process, because if you don't have an awareness, it's going to slip through the cracks no matter what. And who knows, you might be able to identify something that actually has some pretty good value. You know, there was a time when they thought that the idea of ranking web pages by links was silly.
You know, to take the opposite angle of your entire presentation, but just to be mean, I actually felt a lot better about my borrowing of other people's secret, I forget what you call trade secrets, because they're out there sharing what they're doing and they say what they do, and I'm like, oh, that's brilliant, I'll do it. And I always felt, you know, like I'm stealing stuff. I'm like, yeah, hey, they're making it public, right? I mean,
you might be familiar with a concept called funnel hacking, which has been made popular by a company called ClickFunnels. The idea is to look at how somebody's marketing their product and model their customer acquisition and then customer extension phases by, you know, mimicking their marketing.
Right.
Well, they're not advocating copying an ad or copying ad copy and images. In fact, they tell you not to.
Yeah.
But there's enough publicly available information there that you can divine this outline. One of my interests is stories. And Aristotle had this concept of reverse engineering the story to figure out what the theme and what the outline is to the story. And you can figure out, reverse engineer, what the theme of your competition is by looking at their products without stealing their creative intellectual property that's within it. And in fact, if you do that and do that well, you can probably create a better product.
Yeah, I mean, that's the main focus. What I always tell people is whatever you're doing, be customer focused, right? Most businesses they look at themselves and they don't focus on the consumer. So whenever you do what you just said, you're borrowing their idea, you know, tailor it to a specific customer, and chances are you'll have a better product.
Mm-hmm.
Anyway, was that it? Are we good?
That's it.
So, and I'm going to put, I know he had a link. I got one that's a little shorter here. I'm going to put it in here. You had your, this is the link where you can get the NDA. And actually, why don't you clarify what your NDA, because it's a process, right?
It's a basic generic NDA. Whoever downloads this form, and I'll customize it for my clients. But you got to fill in your name because you're the person providing the information. You have to identify who the recipient is. You have to describe the thing that you're trying to protect. You know, a open, generic, blank NDA is unenforceable in most states. So if you just have somebody that says, I agree not to discuss whatever it is we discussed today, the next question you get from the judge will be, well, what did you discuss and what of what did you discuss did you agree to keep secret? And of course, the thief will always say, it's about that much stuff. And you're like, but wait a minute, it's the whole thing. Avoid that. And the way to avoid that is by describing the stuff that you want secret correctly within the NDA. I advocate, go ahead.
I was going to say, honestly, that was worth my time today, just hearing that, because I can't tell you how many NDAs I've done where I don't specify, it's just a blanket NDA. That's brilliant. Thank you.
No, those are very difficult to enforce. The other piece of this is that I encourage your listeners and the people on the call to automate this. And the way to automate it that I use is through an account called EverSign. I take this document, I make it blanks, I upload it as a template. I think you have to pay a little bit more as a template. You can customize it and then upload it as a document for free and then use their program. But it handles sending it out. You get to customize the email they receive. It handles 3 reminder emails. And then it stores it for you along with tracking of when they opened it, if they didn't sign it, when they opened it, they take a quick peek, and then when they actually execute the document. So if you see somebody open it without signing it, you can send them an email, make a phone call. Hey, notice you took a look at this, or just want to know if you have any questions about it. It makes the whole NDA process much more efficient and enforceable when you get to the point of needing to show a judge that you've been doing something called due diligence to protect your secrets.
Yeah, I've helped mutual friends that automate this process of sending it out to a lot of people, and it is a really good system. I mean, it makes things so much easier dealing with a lot of people. So anyway. Anybody have any other additional questions? You got lots of thank yous for your time. Jackie, you had something.
You guys really did.
Yeah. Again, it was kind of what Joe Winograd got to as well, because what I wanted to know, you kind of answered at that point, but it was in a general ballpark type thing with how much would any one of these types of protections cost to file?
Mm-hmm.
Where are we at? Because I can probably estimate what I will make in a year with whichever of my products I'm going for, but I would like to have some kind of idea of what it would actually cost for me to protect it.
Sure. So the short answer, and then I'm going to send you to a resource, is that getting intellectual property is not like climbing a ladder. It's impossible to tell you this is the next rung and this is how much it's going to cost to climb it. It's more like trying to climb a tree when you were a kid. You didn't really know which branch you'd end up on, and there's a different fee for each branch you step on. So it's hard to predict. So what I would encourage you to do is to go to the Thrasher Associates YouTube channel, where I actually walk through the cost and different scenarios for the cost in 3 different presentations. Each of those presentations is about 20 minutes, and it comes with a PDF that you can download at the end of the presentation to try to estimate what your costs will be.
Okay.
I'm putting that link in the chat right now. Just give me a second. I don't know where my chat went. Again.
Yeah, that sounds really useful, because that would be one of the things, right? Because if I have something and it sells a few copies here or there, or maybe just a few in a month and stuff like that, or I have one of the others that's quite a lot more expensive, which I might have a few sales of quite often. That might be much more interested, and again, I have something else that's really taking off, and I might like to do something with that before it gets to a point where I can really lose some money if I don't.
And in these situations, and this is why I'm giving the NDA out right now. The NDA is free. Use it. use it. That's going to save you money, and it's fast. But you got to document everybody that has it and why they have a duty to keep it a secret. It's my mom, it's privileged. It's my director, fiduciary duty. It's my customer, they signed this NDA, or they signed another agreement with an NDA provision in it. So keep track of your trade secrets. That's the inexpensive way to get started.
Yeah, the part with the trade secrets is probably currently where I'm at, because hey, I've kept it pretty secret, but yeah, it's just with publication and stuff like that. At some point, you'll get to.
And by the way, none of this stuff is easy. I have my own software company I'm trying to create product for and got off the ground right now too. And you know what? I work with developers, and I'm constantly having to harass them to send me signed agreements, even though I'm the freaking, IT lawyer, and I'm the one writing them a check. I know how hard this is. You just, sometimes you just gotta go, hey, sign it. You want the check, signature.
Yeah.
And Jackie, maybe that was what you're alluding to, but I know from talking to you, I know at some point maybe you're going to hire out on doing some stuff, some actual work, and I think that was also part of like, what do you need to get them to sign, right? Besides the NDA, and actually, I spent most of my life working in corporate America, and I worked for Department of Defense, the DoD stuff, where you talk about top secret stuff. Yeah, we had a lot of stuff on that, but even then in corporate world, I didn't realize so much of the whole. I forget it. I think I knew at the time, but the whole red folder is the point to make it so obvious, right? But it was more about the mindset of what you're doing with it than it actually was of the logo on the each page.
Yeah, and in fact, at McDonnell Douglas, we had information rooms manned by an information officer who would limit your access to the room, where you had to look and remember what it was you read and then walk out. So you don't have to go that far with trade secrets, fortunately, but you understand that's kind of where this concept of something being secret comes from.
So I did some work for, I think it was Toyota Financial, and they made it where I had to have a safe to literally lock up the data, and I thought how silly, like someone, but now I get it, right? That was what they were doing.
Yes. And by the way, Joe, I want to bring up another point, and we didn't get to this today because this is all about the intellectual property. We've kind of migrated into a discussion of customer agreements and stuff.
Yep.
If you have a contractor who's writing code for you, the presumption under the law is that they own their creation, unless there's a provision in an agreement that assigns it to you.
Wow.
If that person's an employee, the employer is presumed to own it. But if you're contracting out stuff, you need two important provisions. One is the non-disclosure and a non-use provision. A third is the assignment of their creations to you or the entity that you're managing to do the work.
Wow, is everyone writing this down? I mean, that was huge.
Yeah, that one's huge. Yeah.
That's this is why it's great having someone you can get some quick ideas from, because like that probably just saved half of us like some really bad things happening at some point.
Yeah, this is the program for developers. The program for business owners leads with that.
Yeah.
Do you actually own the stuff you paid for is the question I'll frequently open that presentation with.
Yeah, I never would have guessed that.
Oh, you would love the look on faces in the audience when they hear that roll.
Yeah, I bet. A horror look. Yeah.
I don't know how much time we have. Tell you a story. There was this is when I worked at a really big law firm downtown Dallas. We had somebody come through our door who had received a what do you call the document, where someone's basically agreeing to the preliminary steps to buy your company, pending due diligence. You know, it was an intent to purchase, and the purchase price was for over $20 million. And this software company came into us and they said, well, let's button up and get our IP in order. Again, after the fact. Turned out they only used contractors. A bunch of them were international students who had gone home. They had not filed for patents. Their period to file for patents had expired. Did not file for trademarks or copyrights. They didn't have NDAs. They had nothing. And we had to reconstruct everything. The final purchase price for that company, the purchase did go through, was for a little bit more than 10% of the original commitment price. They lost $17 million some odd dollars worth of value.
I hate it when that happens.
Because they didn't have those things buttoned up. This was like right around 20 years ago.
When $20 million was a lot of money.
Middle of the tech bubble, but man, to just see and to hear the absolute anguish on the other end of the phone was it's one of those lessons you just don't forget.
You know, maybe next year you can come back. What would be a painful one, but I think it'd be a great one to learn by, are, present the top 15 mistakes, right, of like the things that and with, especially with an example on each one maybe, but most people learn more by mistake, right? Suddenly you pay attention when you hear how something like this happens. That's ouch. Awesome.
They win.
Thank you. So I know everyone on here, and like I said, we get a lot of people watch this after. So I realized also there's another. Actually, I realized, Jackie, I was laughing because I couldn't get it done in time. But AutoIt is another scripting language. Actually, AutoHotkey's forked from it, and I'm like, I should have reached out to their community and said, hey, we're doing a webinar, which is right up your guys' alley. So I'm going to make sure I share it to them as well. But great stuff. Thank you, Stephen.
Excellent. Thank you, Joe. And Jackie.
Again, so I can say, because I went through it, and actually I even told Steve, it was one of the reasons why actually I called you too, to say, I initially went to his website and signed up and went through his onboarding process, and he doesn't share your email with anybody else, right? Obviously look at what he works in, right? So that's not a concern. But it's a really great onboarding process, and the documents that he sends you, I think is it every day, once a day, somewhere in there, once every 3 days?
So it depends on which website you come in on. If you come in through Thrasher Associates, which currently forwards to thrashlaw.com, you're asked which document you want, and then you get an onboarding sequence that lasts 3 days, and then a sequence of education that can last 5 days, which is about every other day, of an email send to 7. Then if you come through a topical specific page like Thrasher Trademark Law and soon to be published Thrasher Patent Law, Thrasher Copyright Law, there are different email sequences that you'll get triggered into. The trademark ones mirror those. There is a sequence in the trademarks that will send you a video with a quick write-up about 5 days a week, frankly, until you cancel practically. It's a 60-day sequence.
Wow.
But I really want people that hire me to do their trademark work or their patent work or their copyright work to really understand what the process is and what they're doing. And I found that if they go through that sequence, about 98.9% of their questions will be answered.
Cool. Excellent.
Yeah.
Awesome. Well, that we ended up just talking straight through. I didn't even realize like we had blown past the first hour until I looked up and it was a bit after. But thank you so much for being on here today. And,
thank you.
Everyone else will hopefully see you next month. And that's it. Awesome.
Yeah. Thank
Thank
you
you,
all.
guys.
Thanks again, Stephen.
Yeah.
Take care. Bye bye.
Have a good night, everyone. Bye.
Bye.